Somebody asked a question. It's not an uncommon question. I've been asked before. It's on deprivation of rights under the color of law. You can file a complaint with the DOJ Civil Rights Division under conspiracy against rights under the color of law. So I thought it was necessary to answer a question. Statute of limitations for deprivation of rights under the color of law depends on whether it's being pursued as a criminal charge by a federal government, as civil lawsuit by a victim. Criminal prosecution for federal government prosecute a public official under 18 U.S. Code 242. Limitations periods are as follows. Offensive not resulting in death, generally a 5-year statute of limitations. Through certain aggravated acts, carry a 7-year limit. Offenses resulting in death, there is no statute of limitations. Charges can be filed at any time. Civil lawsuit to USC 1983, individuals filing a civil rights lawsuit against official for violating their constitutional rights under the color of law do so under 42 U.S. Code 1983. There is no federal statute of limitations on Section 1983 claims. Instead, federal courts apply the statute of limitations for personal injury claims from the state where the deprivation occurred. In Illinois, where Hickory Hills is located, that's where I'm at, the personal injury statute of limitations is 2 years from the date the violation occurred. Okay, so I always found that a statute of limitations, for them to file a criminal charge or a civil suit, as follows. Okay, so my second comment was they will say in a court, ignorance of the law is no excuse. Counter with ignoring the law to deprive constitutional rights is beyond egregious and unethical, and to oppose statute of limitations for violating one's constitutional rights is in the self-interest concerns of the bar, not in the public interest, thus under the color of law. The profession has a responsibility to ensure that its regulations are conceived in the public interest and not furtherance, parochial, or self-interested concerns of the bar. Okay, so I just stole that from guess where? The preamble, the rules of professional conduct. It says right here in line 12, the legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest and not in furtherance of parochial, religious interest, or self-interest concerns of the bar. So here you are, your deprivation of rights consists of them violating your constitutional rights, due process, a fair trial, effective assistance of counsel, specifically effective assistance of counsel, which the definition for it is given in the Rules of Professional Conduct and the Code of Judicial Conduct. So they're putting a statute of limitations on when you can file and how when you're ignorant of the law. So they're counting on that, your ignorance of the law. And then let's say you do find out, they say, too late. We put a time limit on it. But they knew they were breaking the law from the very beginning, from the very get-go, depriving you of your constitutional rights. But you didn't know the laws. You literally need a law degree. You need to be able to pass the bar to get effective assistance of counsel. And at the very least, you need to learn the rules of professional conduct to find out that what they're doing to you is illegal. Okay, they're supposed to do what's in the public interest, not what's in the interest of the bar. That's why I put it there. They will say in a court, ignorance of the law is no excuse. So counter with, ignoring the law, deprivation of rights, is beyond egregious and unethical. Look up ethics in the, in the legal system, ethics in the courts. And to impose statute of limitations for violating one constitutional rights. That's piling stupid on top of dumb. It's just really stupid. And the law clearly states the profession has a responsibility to ensure its regulations are conceived in the public interest and not furthers parochial or self-interested concerns of the bar. So the statute of limitations was not in the public interest, but in the self-interested concerns of the bar. Simple as that. Okay? Use the law against them. Use their very words against them to stop that stupid statute of limitations. This lady asked a question. She's probably just finding out about what I'm posting, which a lot of people are. But I've been reading the law books before I graduated high school. Most people don't do that, so I've been finding out. My lust for literature isn't common. But I like to help people. So, remember, when you go to this deprivation of rights under the color of law, this is a post from mine from a year ago. And I hope whoever's out there listening, that's very, some people will call it rudimentary argument, but very effective nonetheless. There's no need to use big words that most people can't understand to get your point across. The profession has a responsibility to ensure that the regulations are conceived in the public interest, not in furtherance or self-interest concerns of the bar. The statute of limitations are for filing and suing for deprivation of rights is in self-interest concerns of the bar. That way you can't come back at them for them knowingly and willingly breaking the law. Simple as that, people. Simple as that. I have nothing but love for you, alright? May your Creator always be with you and rain many blessings. I wish you a long life and good health. What they took from me, they took from we, and we need to work together to stop them, alright? They took from one, they took from all. We can work together to get it back. You have a good night.